Welcome everyone to this week's Communication Across the Curriculum, our CAC discussion. And this is a very special tandem presentation between Sarah Chapman of Criminal Justice and our guest philosopher, Whitten from the Philosophy Department. And their title today is A Dialogue on the Philosophical and Practical Justifications for Capital Punishment in the USA. Thank you very much.
Do you want to start us off while we're doing this?
While we're doing this? We're doing this as a product of a number of conversations on the topic down through the years. I always thought that maybe in a future incarnation I might want to do something in criminal justice or something like that. But I've taken particular interest in terms of ethics and political philosophy in terms of the death penalty. And so we had some very fruitful, enjoyable conversations. And Sarah decided she wanted to make a presentation on this and was very gracious to include me in it.
All right, let me see where I need to point this. Awesome. So to start, we just want to define capital punishment, just so that we're all on the same page. So all states in the U.S. are legally authorized to execute offenders for death-eligible offenses. And that just means that the Supreme Court has upheld the state's rights to use the death penalty. They are limited to death-eligible offenses. We have on death row right now about 2,600 people. All of them are there for first-degree murder. There are other death-eligible offenses in the U.S., things like kidnapping, aircraft hijacking, treason, placing a bomb in a bus terminal is a death-eligible offense in Missouri. But there's nobody currently on death row for any other crime other than murder, and nobody's been executed in the U.S. for any other crime other than murder since 1976. Okay, so we currently have 29 states and the federal government and the U.S. military that authorize executions in the U.S. Most states, though, are not actively using their death penalty systems. There's been 1,500 executions in the U.S. since 1976. A third of those were in Texas alone. So Texas has executed 569 offenders since 1976. The second most active state with the death penalty is Virginia, and they've executed 113. So 569 followed by 113, then Oklahoma with 112, Florida with 99, and then it goes down from there. Most states have not executed an offender since the death penalty was reinstated. All right. So I'll say, since 1976 a lot. It's not just an arbitrary year that I pulled out of the air. The death penalty changed substantially in 1976. So in 1972, the Supreme Court invalidated the death penalty statutes of all states in the U.S. So in 1972, they declared the death penalty as it existed to be unconstitutional. It was both arbitrary and discriminatory, according to the Supreme Court, in the decision of Furman versus Georgia. It was a split decision, though, so it was 5-4, so just one justice could have made a difference. But because 5 of the justices were in favor of overturning the death penalty or declaring it unconstitutional at the time, there were 629 people on death row in 40 states, and all of their sentences were commuted to life. So every single person that was convicted and sentenced to death in 1972 automatically had their sentences commuted to life. So the death row population was 0 in 1972. Almost immediately, states began to rewrite their death penalty statutes in order to make them constitutional. Florida actually rewrote theirs within 5 months and convicted somebody and sentenced them to death. So by 1976, there were 5 death row inmates in the U.S. that were challenging their convictions because the Supreme Court had overturned the death penalty in 1972, and yet they were sitting on death row for crimes that they committed since 1972. So naturally, they challenged that in the Supreme Court. And that decision, or that case, was under Greg's name. Greg was the defendant out of Georgia, but it represented Georgia, Florida, Texas, Louisiana, and North Carolina, were the 5 inmates that were sentenced under these newly devised death penalty statutes. And the Supreme Court reviewed the case in Gregg versus Georgia and declared that the new design, or at least the one that Georgia had designed, was constitutional. Basically what Georgia did was it created what they called a bifurcated trial system. So now all death penalty trials in the U.S., rather than have a jury faced with guilty, not guilty, guilty and deserves death, guilty and deserves life, guilty and deserves life without the possibility of parole, or guilty and deserves something else. The jury just has to determine guilt or innocence in the first stage. So it's just like any other felony trial. They're tasked with determining whether or not the prosecutor proves guilt beyond a reasonable doubt. And if they find no, and they find the person not guilty, then it's over. But if they find them guilty, then they go to the second stage of the bifurcated process, and that's the penalty phase. And there they're essentially trying to determine death or something else. If they unanimously agree on death, then the inmate can go to death row. If they don't, then it goes to the judge for sentencing. The judge is most likely going to impose a sentence of life. That is the most simplistic explanation possible. There are all kinds of exceptions. There are judges that overturn jury decisions. Theoretically, the jury determines whether or not the inmate deserves death, and if they don't, then it goes to the judge to impose a different punishment. And so this kind of moratorium on death sentences was lifted in 1977. The very first person was executed in the U.S. since the death penalty was reinstated. That was Gary Gilmore. He was executed in Utah. He was actually executed by firing squad. So he was the first person executed. It's also notable that he was executed in 1977. Death penalty wasn't officially reinstated until 1976. That is like lightning fast for our death penalty system. He waived all of his appeals. Death row inmates have automatic appeals. Every death sentence is automatically reviewed by the appellate court system, and he waived them. And in fact, the appeals are so automatic that he had to fight to waive them. So he had to hire an attorney to fight for him to have the ability to waive his appeals so he could just go in to his execution. Okay, so of the 1,516 executions since 1976, most of them have occurred in Texas, almost 600 of them. Most of them have occurred in the South. Out of 1,500, 1,241 have occurred in southern states. Most of them were by lethal injection. 1,336 of 1,500 executions were by lethal injection. The other four methods of execution are electrocution, gas chamber, firing squad, and hanging are four legally authorized forms of execution in the U.S. today. And then most of the 1,516 inmates were men. 1,500 total. 16 people executed since 1976 were women. All right. Oh, and then there's been a few changes. So even though these are the two big, the Furman and the Gregg decisions are the major landmark cases in the death penalty, that doesn't mean that death penalty legislation stopped in 1976. They're constantly refining kind of the ends of the death penalty. So in 1977 in Coker versus Georgia, the Supreme Court said that it would constitute cruel and unusual punishment to execute a rapist. So the death penalty is disproportionate to the crime of rape. They interestingly use the phrase the rape of an adult woman though. So a lot of states are playing with where the end of that is. Can you execute the rapist of a child or the rapist of a man? So that legislation is not over either. In 86 in Ford versus Wainwright, the Supreme Court declared it unconstitutional to execute the mentally insane. And then in 2002 in Roper versus Simmons, they prohibited the execution of anybody who committed their crimes prior to their 18th birthday. This went through a lot of legislation as well. For a period of time it was 16, and then it was 17, and then it was you can't execute them until they turn 18. So somebody commits a crime at 16 and they sit on death row, become eligible for the death penalty when they turn 18. But finally in 2002 they said if you commit the crime before 18, you can never be eligible for the death penalty for that crime. And then that's just from the federal level. The federal government is continuing with the Supreme Court to legislate the death penalty. They're looking at things like juror bias, PTSD, the impact of having a rough childhood on the decisions adults make, methods of execution, whether or not the states can continue to use things like the gas chamber and electrocution. And then at the state level, there's lots of proposed legislation as well. I looked up a chart earlier that showed all of the bills going through different states, and they're addressing all kinds of issues like limiting death row inmates' access to the state appellate courts, exempting serious mental illness from being eligible for the death penalty, amending the commutation procedures, the ability of the governor to commute sentences for death sentences, annual inspections of execution chambers. For every state that is proposing a bill to repeal the death penalty, there's a state proposing to initiate the death penalty. So there's a lot of controversy across the states and how the death penalty is viewed and implemented.
Second part of our presentation is kind of a back and forth with particular issues that Sarah and I think are most important, either in arguing for or arguing against the death penalty. A major argument against the death penalty is appeal to evolving standards of decency. I want to say at the outset that I, like many people, when I'm confronted with the taking of an innocent person, the crime of murder, I do feel a sense of outrage, I feel a sense of anger, I feel a desire for payback. That's a psychological response that I have that's entirely understandable and appropriate. And yet standards of decency say I think you can't just go with your initial psychological response. I think our standards of decency have been developing down through the years. I watched just the other evening another episode of my favorite television series, Outlander. Jamie and Claire are back in pre-Revolutionary War in the United States. And there was a riot, and people took some British officials into custody, and then they tarred and feathered them. Now, I think when I was growing up in elementary school, I thought it was kind of like dumping molasses on somebody and putting feathers on them, and very humiliating, so on and so forth. Now, this was hot tar. This was a torture. And they did a pretty good job of presenting in the show itself the kind of aftermath of being tarred and feathered. Well, we don't tar and feather people anymore, though this was a practice during the time of our founding. We don't cut off the hands of pickpockets. We don't castrate rapists and that sort of thing. If decency is tied to nonviolence, or at least a limitation of violence, and to the type of violence that we might perpetrate, while this is oftentimes dismissed by conservatives, and I'm a pretty conservative guy myself, I find that there is something to this evolving standards of decency. I certainly understand why others, and why I myself am inclined to think that one argument against the death penalty is just that it violates my standards and the standards of many people when it comes to decency. Tied to this traditional justification is tradition. We just have a tradition of capital punishment. It's been a part of our legal system. It's been a part of our public morality for generations and for centuries, and certain acceptance of tradition. I always like to say that while tradition is a good resource and can be a good guide, tradition is a terrible master. And it's absolutely appropriate to emphasize it is very traditional to question and to challenge tradition. And many of the traditions that we might consider upholding today at one point were challenges to and alternatives to previous traditions as well. So I think our traditions for what we've called just punishment need to be challenged, need to be questioned. The value of human life is a third consideration, and actually both sides argue the value of human life. Pro-death penalty persons argue that this is the only punishment that is proportional or commensurate with the crime that is perpetrated. And so the only appropriate response to show how highly we value life is that to compensate for that, and in some sense of compensation, by the taking of the life of the innocent person. I would emphasize that this sort of argument does depend upon a proportionality argument, which Sarah's going to get to in just a moment, that somehow capital punishment, the death penalty, is required because it's the only proportional or proportionate punishment that is appropriate for the crime that has been inflicted. Against the death penalty, the argument would be that all of life is sacred, and that even a guilty human life is not without value, and even a guilty human life is capable of rehabilitation. And in fact, there have been people who have been charged with capital crime. There have been people who have been executed and yet given every indication of having actually been rehabilitated. We did not execute the person that was convicted of the crime. Here in Texas, the last woman to be executed was Carla Faye Tucker. She did commit, there seems to be no doubt that she committed a very grievous murder. During her time in prison, she had a spiritual experience. She became a born-again Christian. She gave every evidence that this was not a, come to Jesus experience in prison that many people argue. People like Pat Robertson of CBN argued that Governor George W. Bush commute her sentence. He did not, and she in fact was executed. So if we do value human life, this is how argument goes against the death penalty. If we recognize that all human life has value, and all human life can even progress in that in terms of rehabilitation, this is an argument by a number of people against the death penalty. However, again, the value of human life has been used as an argument in favor of the death penalty as well.
All right, so related to that is the idea of proportionality, or the use of the death penalty as retribution. It is shocking how easy it is to find death penalty related cartoons on the internet, so there's one for every slide. So retribution requires us to see that the death penalty is the only just sentence for an eligible murder. Otherwise, we can't use that argument. But the death penalty is used in fewer than 1% of all murder cases. So in last year, 2019, there were 16,000 murders known to the police. 22 people were executed, 34 death sentences were handed down in the year. Even if we combine those, these are less than 1%. It's actually 0.02% of all murders resulted in a death penalty. And so for the other 99.998% of murder victims, we're kind of left with the belief that their lives were somehow less valuable, that their deaths didn't justify the same degree of punishment as those 0.002% of victims. When you add into that this layer of the race of the victim being relevant to the sentencing decision, the single most predictive factor on whether or not an inmate or an offender will receive the death penalty is the race of the victim. In some states, it's 3 to 4 times more likely that an offender will receive the death penalty if the victim is white than if the victim is any other race. And so now we have a system where people are statistically very unlikely to receive the death penalty, and the odds of receiving the death penalty seem to be very tied to the race of the victim, which makes retribution no longer a valid argument. Deterrence is another big argument in favor of the death penalty. How do we get people to not commit the crimes if we don't have terrible punishments to apply? There's really no empirical evidence of any deterrent impact of the death penalty. States without the death penalties consistently have lower rates of murder than states with the death penalty. The South has the highest murder rate in the U.S., but also has the highest rate of executions in the U.S. When states repeal their death penalty statutes, if deterrence was a true impact of the death penalty, we should see spikes in their murder rates. If the death penalty is no longer a threat, then all of these people who were deterred from committing murder because of the threat of the death penalty should now feel free to go and commit their crimes, and yet we don't see any such spike in murder rates. In fact, Washington is one of the last states to repeal their death penalty. They repealed the death penalty in 2017. Their murder rate has gone down since. So 2018, 2019 were lower than their murder rates during the time that they had the death penalty. I also looked up the murder rates of individual states. 7 of the top 10 states with the lowest murder rates do not have the death penalty. So only 3 of the 10 safest states in the U.S. even have the death penalty. Of the 5 most dangerous states to live in, 3 of those states do have the death penalty. And one of them, Alaska, is just a statistical anomaly because we're talking about the rate of homicide, so it uses the population. Since the population is so low in Alaska, it makes those numbers that you can't compare with the rest of the states. So of the 4 most dangerous states in the U.S., 3 of them have the death penalty, and yet the death penalty doesn't appear to have any real impact on those rates of violent crime.
Yeah, to kind of build upon that before I move forward. At best, I would say that the deterrent factor is questionable and speculative. It's sometimes argued, well, but how could we have evidence? If somebody were deterred from committing a murder, we would never have any evidence that they had been deterred from a murder, which makes a certain degree of sense. But for that to be any part of an argument would be an argument from ignorance. Well, we don't know that it hasn't deterred, so it must have deterred, and that would be an argument from ignorance. As I tell my students in my classes, what we don't know is not evidence for a claim. Sarah and I were talking earlier this afternoon about phenomena in Britain, in Old England, 16th century. Pickpocketing was a capital offense. But pickpockets regularly worked the crowds at the hanging of pickpockets. So much for the deterrent effect of that. The deterrent argument seems to assume that criminals or someone who would commit a murder are kind of rational cost-benefit analysts. And they're not rational cost-benefit analysts. And there have been a study or two that I saw has been indicated that they actually believe that they won't be caught, they won't be convicted, they won't get the death penalty. I would also emphasize before I move on, unless the person truly deserves to be executed, the deterrence argument in and of itself is not a good argument. You would have to be guilty and deserve to be executed in order for the deterrence argument maybe to add to that as well. Moving on though, the execution of innocent persons I think is perhaps my chief concern, my chief objection to capital punishment. It is, in my judgment, not only reasonable but demonstrable that we have executed innocent persons. And if you'd like to do a little research on the execution of Jesse Tafero in Florida, 3 persons were convicted on the same evidence, I believe in the same trial, but on the same evidence for murder. Jesse Tafero was executed. Subsequent to his execution, new evidence came to light, and the other 2 people who had been convicted of murder on the very same evidence were acquitted. They were let go. You cannot undo the execution of Jesse Tafero. Not only reasonable, but demonstrable that innocent persons have been executed. They come very close to being executed. Some of you may be familiar with the movie The Thin Blue Line, the example of Randall Dale Adams here in Texas, who came, I believe, within 3 days of being executed. And here it was a filmmaker, Errol Morris, through his investigations that came up with new evidence that avoided the execution of Randall Dale Adams. Anthony Porter in Illinois was on death row. They had to delay his execution because of concerns about his IQ, his mental competence. He came within a few days. In this case, it was a college journalism class at Northwestern University that uncovered new evidence that resulted in his not being subjected to the death penalty. I don't know about you, but I personally don't want to depend upon a legal system that depends upon filmmakers and college journalism classes to ensure that justice is being served. I would add to that, the death penalty does make rehabilitation impossible. And I do think, at least for me, it needs to be part of both an ethical and a spiritual concern that people who continue to have value do have a chance at rehabilitation. And there is example after example that we could give you of persons who've been convicted, sometimes the murdering of a police officer, who later on in prison have been rehabilitated, have ended up helping other prisoners, have written children's books, and so on and so forth. So while rehabilitation may be a rare phenomenon, I don't have any access to the statistics there, it is most definitely a possibility. And then I just would point out the non-necessity to protect society of the death penalty. Because we can protect society from people who would commit murders, who would do so subsequently, by life in prison without parole. It was always, when I first became interested in this topic, just amazing to me that until fairly recently, Texas did not have the possibility of a sentence of life in prison without parole. So it was either life in prison with the possibility of parole, or it was the death penalty. Since we've had life in prison without parole, again, from my perspective, particularly in Harris County, death penalty trials and convictions have gone down because now we have an alternative to the protection of society. We have an alternative that will inflict a punishment that's as close to appropriate as we can by the practice, the judgment of life in prison without parole. are also issues about police misconduct and prosecutorial discretion misconduct, and that's what Sarah has
Also,
to talk to us
I
about.
would like to add to the life without the possibility of parole. I think the statistics are about 61% of citizens would favor some other sentence to death. So in states where life without the possibility of parole, there's also a life without the possibility of parole plus restitution that some states are using, and then life even with the possibility of parole. 61% of people prefer one of those sentences over the death penalty. So this is evolving standards of decency. Traditional argument is also starting to chip away with kind of a belief that something else might work better. And in terms of fiscal responsibility, it costs approximately $2.3 million from the time a person is arrested till the time that they're executed. So every single death row inmate costs about the state of Texas about $2.3 million. This is specific to Texas. That is 3 times the cost of convicting somebody and sentencing them to a single cell at the highest level of security for 40 years, which is essentially a life sentence. So it's 3 times more expensive to execute a person in this state than it is to sentence them to life in solitary confinement where they wouldn't be a danger to other inmates and general population. Okay. But with official discretion and misconduct, prosecutorial misconduct is the second most common reason for reversible error. So when appellate courts reverse a decision of the trial court, the second most commonly cited reason for that is prosecutorial misconduct. And that can range from juror selection, suborning perjury, allowing a witness to lie on the stand, using questionable witnesses like jailhouse snitches, and relying on that testimony, treating co-defendants differently without any just reason for why one is sentenced more harshly than the other, withholding exculpatory evidence. All of those things are forms of prosecutorial misconduct that are cited as reasons for reversing a conviction. The difference, of course, is that you can reverse a conviction even for a life sentence and do something about it. But if that prosecutorial misconduct isn't uncovered until after the execution has gone through, then that reversible error is a lot more meaningless. In Harris County right now, there's 69 convictions that are under review because they were all investigated by a single officer. He happens to be the officer that was involved in that. You guys remember that drug bust?
Yeah.
And the 2 residents were killed? Well, apparently in his application for that warrant, he just lied. He claimed that an undercover informant had gone in and purchased drugs from that house. Never happened. And so the search warrant itself was granted on false information, and then of course they went in with guns blazing and 2 people ended up dying. So now every single conviction that he was involved in investigating is now under question. There are 69 people still currently incarcerated from a Harris County conviction that are now under review to determine whether or not he also lied in those cases. And so again, we can do something about these 69 individuals that are still here, but if one of them had been executed, there's not much you can do to repair that error. All right. With respect to economic insufficiencies, there's a quote that says those without capital get the punishment, just meaning that it is the indigent defendants, it's the people that don't have the ability to pay for a good defense that end up receiving the death penalty. The death penalty is kind of a bargaining chip in a lot of states, so the prosecutor doesn't necessarily want to send you to death row because the prosecutor acknowledges all of these economic and social reasons not to pursue the death penalty. But in terms of plea bargaining, it serves as a pretty useful tool. Either I can take you to trial and seek the death penalty, or you can just admit guilt and get something else. And the better your attorney, the more able you are to negotiate those terms of an agreement. So since 1963, the Supreme Court has declared that states have to provide counsel to indigent defendants or defendants that can't afford it. It's written into the Constitution as part of our 6th Amendment rights, but it wasn't until 1963 that the Supreme Court said, okay, we got to actually do what the 6th Amendment says we have to do. But most people on death row were represented by court-appointed attorneys. And just to give you some statistics, because each state differs, so I couldn't bore you with 50 states worth of information. In Alabama, court-appointed attorneys earn $40 an hour for in-court work and $20 an hour for out-of-court work, with a cap of $1,000 per case. Death penalty cases will likely go weeks, possibly even months, and they cannot get paid more than $1,000 for that case. In Texas, the average court-appointed attorney makes $247 total per misdemeanor case, $598 per felony case. With a 2018 budget of $273 million and 475,000 indigent defendants, there's an average pay of about $575 per case that is litigated by a court-appointed attorney in the state of Texas. So there's just not a lot of money there. There's not a lot of motivation for an attorney to really dig in deep and do the best job possible. Is this me as well? Discrimination. So race is, it's a difficult factor associated with the death penalty because supporters of the death penalty and people that want to deny the racial impact of the death penalty will point out that death row is fairly even in terms of racial composition. So it's 42% black, 42% white, and then the rest of the death row is made up of other races. Of course, Black Americans only make up 13% of the total U.S. population, so significantly overrepresented on death row. But the much more relevant statistic is the race of the victim, and nobody can deny that. In fact, the Supreme Court saw a report in the 80s in a case called McCleskey versus Kemp, where they outlined the racial discriminations of the death penalty, and the Supreme Court essentially says, yeah, we see it, but you can't prove that it was intentional, so it's not enough to justify overturning the death penalty. It doesn't amount to discrimination because it's just incidental racism, not intentional racism. Texas has one of the highest representations of minorities on death row. 74% of people sitting on death row in Texas are minorities. Since 1976, there have been 315 executions for interracial murders. 294 of those have been for a black defendant murdering a white victim. Only 21 have been against a black defendant for the murder of, against a white defendant for the murder of a black victim. So statistically, more likely to be sentenced to death if your victim is white, and statistically even much more likely to be sentenced to death if you also happen to be black. Oh my gosh, I'm talking a lot. All right. And then one of my soapbox ideas is this idea of closure. You hear this all the time too with supporters of the death penalty, but it gives the family closure and they can finally rest. My problem with the idea of closure in the death penalty is that most of these cases take 10, 20, 30 years to go through the system. And so it is 30 years from the time that you lose your loved one until the time that you finally get that closure. And I don't know, because I've never been the victim of a capital murder. I've never experienced the capital punishment from a victim's point of view. But I imagine when you put off closure for 30 years and you've banked it all on this single moment where somebody dies, that's got to fall flat. That can't fill in all of those holes that have been there for 30 years. So in my opinion, this idea that we can put off self-healing and dealing with the consequences of being the victim of a homicide, just waiting for this one event in time seems to be kind of setting up a victim for more pain.
Some might argue that one way to deal with this problem of closure or even the expense is that we just need to execute people more quickly, streamline the appeals process or whatever. But once again, if you streamline or cut down the appeals process, you are again guaranteeing that you're going to be executing innocent persons. Might just as an aside tell you that the Starz Network on Sunday nights has a new series called Wrong Man, Wrong Person, in which a team reinvestigates some old crimes, typically back from the 1990s, looking for new evidence that might lead to exoneration. They typically do, but you can't watch that series without actually becoming angry at sometimes either the incompetence and or the perversity of prosecutors and investigators who have been behind the convictions of some of these persons. And one gentleman was very recently released after 20 years in prison for a murder that he did not convict. Now, if you had streamlined the process, or if he had actually been given a capital sentence, he would not have been around, and probably that investigation would not have even taken place. It once again amazes me that there actually have been prosecutors who have not only been indifferent to, but have fought against the institution of the penalty of life in prison without parole, and also have been indifferent to, and sometimes even fought against DNA testing. I understand psychologically why people's egos might lead them to do such things, but ethically and legally, I think it's absolutely atrocious. Well, this third and last section is at least novel to me. I'm sure somebody's done what I'm about to do somewhere, but I've not cared to really investigate very closely. But during my doctoral examinations, my written examinations, and my ethics examination, I was required to discuss the just war tradition. You know, when you declare war, you are pronouncing the death penalty upon your enemy. And of course, your enemy is pronouncing the death penalty upon you. Tens of millions of people were killed in World War I. Tens of millions of people were killed in World War II. Hundreds of thousands of people have been killed in other wars since that time as well. So it occurred to me while in the process of writing about just war, criteria by which one might evaluate whether a war would be just or not, and what those criteria might be that would be a guide to decision making or sometimes a critique of the decision that was made, it occurred to me that this could be applied to the death penalty, because in both cases you're pronouncing a sentence of death upon an individual or individuals. And so sometimes it's kind of divided up a little different ways, but there's 7 basic criteria in the just war tradition in terms of criteria by which you would judge whether a decision to go to war or the conduct of the war fulfilled the requirements of justice. First and foremost, there has to be a just cause. If there's not a just cause, no matter what else there might be, if there's not a just cause, it's not justified in accordance with just war tradition. Well, the argument is that justice requires the death of a murderer. The lex talionis, eye for eye, tooth for tooth, life for life. We've already raised some of the issues about proportionality here. The real death is actually not a proportionate punishment for many people who commit the death penalty, because sometimes there's in the context of a rape and a murder. Well, we don't sentence somebody to being raped and then murdered. Sometimes it's in the context of a serial murder or more than one individual being murdered. Well, you can't execute a person over and over and over again to match the number of persons whose lives that they had taken. So this proportionality argument seems not to strongly support the just cause tradition, and it does all depend upon this theory of retribution. A lot that we could say on both sides of that, but if the theory of retribution is not the best or most appropriate theory, then it's highly questionable to me, though there is some question, as to whether any instance of the death penalty could fulfill this just cause requirement. Second, it has to be instituted by rightful authority. Now, here's where I think our present system of capital punishment does fulfill the criteria, because it is our legal system. There is a jury of the peers. There is the law in accordance with the laws, an appeals process. So I can't object to capital punishment on the basis that it's not declared by rightful authority. And in a war, a governor of the state of Texas can't declare a war on Mexico, okay? That would have to be constitutionally a decision by Congress or the powers of the president as commander-in-chief. So it has to be right authority. I will certainly recognize that this seems to be fulfilled by our capital punishment system. Third, there have to be right intent. The intention of executing a person must be the intent to preserve or to restore justice. So there is the question, does capital punishment restore justice? Is there any kind of restoration that takes place? Well, you can't restore the person who's been murdered. That is a travesty. That is a tragedy. That is a monstrous act but there is no restoration of a life that's already been taken. There's no sense of restorative intent here. Subjectively, I'm quite sure that many people, advocates of the death penalty and prosecutors, do have, as they understand justice, the intent to do justice. The question is whether this objectively fulfills the standards of justice. And once again, we're back to this fundamental criteria number one, just cause. There can only be right intent if there is in fact a just cause. If there's no objective just cause, there can't be an objective right intent. People are mistaken about the intentions that they have. Number four, it must be initiated as a last resort. In preserving or protecting justice, in order to go to war, it must be last resort, not a first resort. All other nonviolent, more peaceful means must be exhausted before the decision to go to war can take place. Apply the death penalty, all other means of protecting society, all other appropriate means of punishing the criminal must have been taken advantage of before there could be an execution. We have life in prison without parole. In my judgment, this is the best punishment that we can inflict upon a person, and this does, in fact, protect society. So I fail to see that the requirement of last resort is fulfilled. Number five, reasonable chance of success. Even if you had a just cause in war, even if it was going to be declared by rightful authority, even if there was right intent, last resort, if there was not a reasonable chance of success, it still would not be a just war. Because you will not succeed, it will only increase suffering, pain, loss, and death. So the question is there a reasonable chance of success in punishing those who deserve to be punished if they deserve to be executed, and only those who deserve to be executed? Here, once again, my major concern for the innocent, the execution of innocent persons. I do not think that our present legal system or any conceivable legal system can guarantee sufficiently that a reasonable chance of success of determining who does deserve it and who does not deserve it. Sarah has already pointed out that 99+% of persons who commit murders don't get the death penalty. Maybe from some cosmic perspective, some of them did, most of them didn't. The small percentage who were executed, from a cosmic God's eye perspective, maybe some of them deserved it, maybe, but almost surely some of them didn't. I don't see this reasonable chance of success. The one criteria of just worth the theory that really gives me pause, though, is the proportionality argument. Proportionality argument in regard to war is you can't use excessive means. So during the second Iraq War, I heard from some people, let's just nuke them and turn Iraq into a parking lot. No. Excessive, disproportionate, not what was required. We haven't used nuclear weapons since World War II. Why? Not necessary, excessive, disproportionate. I do resonate with the sense that the only punishment that seems to be proportional to causing the death of another person is the death of the perpetrator. I'm reminded of that scene in The Unforgiven where Clint Eastwood says it's a terrible thing killing a man. You take away everything he has and everything he's ever going to have. So someone who commits a murder, they have robbed that person completely, totally. Everything that they had, including their life, and everything that they were going to have. Part of me very much resonates with, it seems like any other punishment seems to be less proportionate to the actual harm that was inflicted. Death penalty, though, is not excessive, according to that point of view. It's not more than they deserve. I've already argued that actually a death penalty would even be, in a sense, less than a person deserves if they deserve the death penalty. I underline if there. So of all of the criteria of just war theory that might be argued in favor of capital punishment, I think this proportionality would be perhaps the strongest in favor. But again, that only works if all these other work, and particularly the first one with regards to just cause. Lastly, there has to be discrimination, non-combatant immunity. I have two major concerns here. One, the execution of innocent persons. But secondly, I have a concern, and Sarah brought this up in our conversations, about the family of those who are executed. They too are being punished. They too are suffering a loss. And yes, the family of the victim also suffered and experienced a loss. But we're inflicting, through the death penalty, a non-discriminatory punishment that does not simply affect the person who's been convicted and executed, but also their family members as well. So when I look at these 7 criteria of just war tradition, I see some question as to whether or not there might be just cause. It all depends upon this retributive notion of justice. I see right authority as being consistent with the death penalty. I see right intent as being highly questionable. I see last resort as absolutely not supporting the death penalty. I see proportionality as questionable, and again, probably the strongest argument in favor of the death penalty. I find the discrimination criteria as not being fulfilled. Again, the problem of executing innocent persons. You say, well, has just war theory ever stopped the war from taking place? Well, I don't know that we would know if it did, but I kind of doubt it. But retrospectively, has just war theory ever undermined support of a war? Well, I think that happened during the Vietnam War. I think increasingly a number of people looked at the war being conducted in Vietnam, whether it was intentionally or not, in terms of many of these criteria, and increasingly more and more people saw the war in Vietnam as being unjust. The second Iraq War, some of you may remember we had a panel discussion on that. And as I recall, it was very easy to recruit faculty members who were critical of the second Iraq War. It wasn't so easy to recruit faculty members for the other side, presenting arguments in favor of the Bush administration. Well, being blessed or cursed, sometimes at least, with the ability to see arguments on both sides, I volunteered to try to argue for the second Iraq War. I used this criteria and I invoked what's called anticipatory self-defense. In a nuclear age, you can't wait until someone drops a nuclear bomb on you before you respond. You may have to engage, but I said this was out on a limb, it was out on thin ice, and at that time I said it will all depend upon whether we actually find an operational weapons of mass destruction program in Iraq. If we do, then I think I thought the war could be justified. If we did not, I said at that time, then the war would not be justified by just war criteria. We found no operational weapons of mass destruction program in Iraq. So by this criteria, the second Iraq War was not justified. Extending this and applying it to the death penalty, I find in my own judgment that applying just war theory to the institution of capitalist punishment, at least by a preponderance of the considerations, if not a compelling majority of the considerations, I come to the judgment that the death penalty cannot be supported if you apply just war criteria. I think you have one final comment or slide or something, don't you?
Another comic? This is what I think every time we do a debate in class, this is what it comes down to. I think that there are measurable arguments against the death penalty, and then there's that unmeasurable sense that something has to be done, though. And that's where vengeance, not exactly a positive term, but it's that feeling that somebody deserves a punishment, and that's what you're weighing when you talk about the death penalty.
And that's what we've got. So what do you have? We'd love to hear your thoughts and give any intelligent responses we might be able to give.
We're talking about the just cause, and you compare the death penalty to the war. When you start a war, your opponent might kick back, but in death penalty, the guy is tied to the bed. He will not do anything. He will not be able to. How do you compare that in that case?
Well, in order to declare a war, one, self-defense is a just cause. So when Congress declared war on Japan after Pearl Harbor, that's a paradigm case of just cause, self-defense. Wars have been justified for all kinds of reasons. Some say war cannot be justified, that's pacifism. Some say wars are justified because God wills them. That's a kind of holy war justification. And typically people do invoke God, sometimes on both sides of the conflict for their declaring the war. There have been wars of national conquest. Might makes right. Hey, we can do it, and so we'll do it. There have been wars of national interest. Just war theory is in contrast to all of those perspectives. It's not pacifism. It's not holy war. It's not wars of conquest. It's not wars of national interest criteria. So the just cause would have to be in terms of a violation of justice or an attempt to restore justice. So if the retribution theory is appropriate, and again, whether you call it vengeance, whether you call it outrage, whether you call it a kind of a metaphorical thinking of a balance of scales that needs to be brought back into balance, I understand the outrage. I understand people's feeling of vengeance. I would have those feelings, I'm sure, myself, if someone close to me were being, or had been murdered. But the question is outrage or vengeance just cause? From an ethical perspective, I can't see, as profound and understandable as those human emotions are, I cannot see those constitute any kind of just cause. Then the question is, well, if not, is there any other thing that supports it as a just cause? And if the theory of retribution and proportionality cannot be sustained, then I don't know how it can be at all. Did I even address what you asked?
Yes, yes, thank you.
Well, I have a question. I don't see how you talk about just cause apart from ideology.
Mm-hmm.
And once you bring ideology into that, it becomes much more muddy. And if the only way to clarify whether something was a just cause is when it's over, like the Vietnam War, although the protests started during the Vietnam War, I think that again is bringing ideology into this.
Yep.
And yet you talk about these concepts as if they somehow have absolute value.
The just war tradition grew up in a theory of perspective on reason, which I know you do not share.
Wait a minute.
No, I'm absolutely sure that you don't share their understanding of reason along with our discussions. Okay? And that doesn't mean you're wrong. I'm simply saying it arose in a context in which reason was understood to give us, if you want to put it, non-ideological, objectively correct standards. We both know how difficult it is to make that case now, but that's the context or the soil within which it arose. On the other hand, while I understand the role of ideology, I do think that probably most people at least share some paradigm cases of what would constitute a just cause and what would not constitute a just cause. There would be disagreements. Yes, absolutely there would be. But I think you can make the case from kind of a paradigm case point of view that there are clear examples that most people would accept as just cause and clear examples that people would regard as not being a just cause. But it definitely arose in a very different context, pre-modern context, certainly pre-postmodern context. And if you understand and challenge the assumptions there, then that does raise a very important issue that you just raised. Maybe it is more ideology than it is pure reason. Yes, sir.
Kind of philosophical question. Who is more important, the individual or society? We always talk about and around individuals, it's good for individualism. Why don't we talk about society? If somebody committed something horrible, then from the point of society, it is extremely important to take any possible measures, okay, to exclude the very possibility of this to be repeated once again. So, I mean that execution is not just execution for the individual, that is protection of society. So, who is more important, the individual or society?
Take a stab at that. That's what you say. Take a stab. Yeah.
I think there are lots of offenders, people that pose a threat to society that are allowed to be in society. So I think it's a slippery slope. I get that capital murder is different, and when we're protecting society from murder, the stakes are higher. But I also think that we can't kill everybody either. I mean, it would be 16,000 people last year alone that would have to die if our sole concern was ridding society of people that pose a danger. And those are just the murderers. I mean, rapists are kind of a big deal too, and aggravated robbers, don't like them either. I don't know.
I think it's a really
society
good,
of dangers.
really good question, because what I hear you saying is that, what about at least a perspective where society is understood more in an organic sense rather than an individualist sense, okay? And in an organic view of society, it's society that's most important, and the individual is secondary. In a more contractarian individualist, it's the individual that's important, and society takes a secondary view. So our society is pretty individualist contractarian, and our legal system is individualist as well. So we have a presumption of innocence in our legal system that other legal systems of the world do not have, because they have a more organic view. We would rather a guilty person go free, even though that might be a threat to society, than an innocent person being punished, which is a threat to the individual. So this is very much within the frame of reference of our country, our legal system, and our kind of general American philosophical view of what society is. But you're very right to point out there are other societies, cultures that have a more organic view.
I think about the idea that this is a good time for, and we are approaching the moment when instead of execution, all this stuff, there will be invented with the development of science, technology, something to stop, to prevent wrong inclinations, okay? That is complicated right now. It is questionable from the moral point of view, but if to, implying to bring some kind of stopper, you know what I'm talking about? So the person would live, okay, within society, but as soon as there is something, will start, raise again, stop. And I think we are approaching this moment.
Yeah. Well, certainly it connotes kind of a Brave New World type scenario. I'm also thinking now of iRobot, in which I forget what the computer's name is, but humans can't take care of themselves.
I was inspired by
restrict individual liberty. The individualist, the libertarian in me strongly reacts against that. On the other hand, the opposing point of view is not irrational or insane. It may be, in some sense, I would say unhuman, but it's not irrational or insane. I certainly hope that that doesn't occur, that kind of control of individuals and human beings.
I have a really concrete question. You had mentioned it was like, how many million, 2-point-something $2.3 to execute someone? Yeah. Now, why is that?
So it starts at the beginning. The investigation is going to be longer. The prosecutor is probably not going to be one of your assistant DAs. It's going to be somebody that is more costly. Your defense attorney has to be a death-eligible defense attorney, so they have to be paid more. And then the jury selection process, the jury that serves on a death penalty case has to be death-eligible. It just means that they can't have a fundamental objection to the death penalty. They have to at least be open to the idea of imposing the death penalty, which means they have to call 3, maybe 4 times as many jurors, and the jury selection process takes 3 to 4 times longer. And then you have more expert witnesses, and the amount of time that your court-appointed attorney spends on the case will be longer, and so all those costs add up. But then it really starts inside of death row. So when they're convicted and sentenced, all death row inmates have to be segregated from each other. So they all live individually. They're all in their cells 23 hours a day, so their cells have to have shower and bathroom facilities and places to eat and area to move around. They have to have individual rec time. They have to be one-to-one supervised whenever they're out of their cells. So the cost of incarcerating them is really high. And then the appellate process is incredibly expensive, and it's automatic, so the state has to pay for all those automatic appeals to move up through the state process and then also federal, since it is a constitutional issue, you're denying them their right to life. And then the execution drugs as well. You guys have probably seen some of that. There's one manufacturer that's kind of had a corner on the market and realizes that they can charge whatever they want. And so even up until that very last moment of administering the cocktail that ends their life is really costly as well. It's a combination of all those things. And the official statistic is that I think the average number of years that a person spends on death row is like 12 to 13 years. But I had this pipe dream that one day I'm going to actually write down every execution that's occurred and figure it out, because it can't be right. I don't know if that statistic is still pulling death row from the 80s and 90s or even pre-70s, because I mean, the guy being executed next month has been on death row since 91, so nearly 20, 30 years. In Florida, they recently actually removed a guy, commuted his sentence to life after 34 years. In California, you are heads and shoulders more likely to die of old age in death row than to be executed. They just don't execute anybody. The federal government hasn't executed anybody since 2001, I think. California, 1996. It's just a lot of money that they're spending to warehouse people, essentially. It's 2,600 people on death row in this country.
I think you said 40 years, and I was wondering, is that really the amount of time that it takes for someone to be convicted and actually be executed?
With the way the system is set up now, and 40 years is a bit on the higher end, but 20 to 30 is pretty consistent. I mean, even, what was his name? He killed James Byrd, the Jasper killer. What is his name? John King. He was on death row since 98, and he drug a man behind his car until he was torn limb from limb. Like, if there is a reason to fast track the death penalty, it's for that. And he was still on death row from 98 until last year, yeah. And with no speculation about his actual innocence, and his execution still took over 20 years.
So in the continuing with Monica's question, since we have this modern knowledge of, okay, people are on death row who may be innocent, and they're spending $2.3 million. And so in a way to cut the budget, why not take the $2.3 million and invest that into, okay, so we know these cases are possibly suspicious. How about take $300,000 and invest that into, let's look at this case and we can possibly find that this person is probably innocent, and we've saved how much money versus 2.3 million for, because we've got too many cases of people who've been in prison 23 years, which is why what you said, because I am a conservative. So I was, yes, the death penalty for these particular reasons, but then it started coming out, hey, you've got these people who are innocent. I don't want to be the person who is sending someone to death because you can't undo death. So then cut the budget in the sense that in terms of that spending, because you just said that the defense attorney gets $585.
Yeah.
So of this $2.3 million,
Yeah.
this is the reason why you have
Yeah.
people not getting a true defense.
Yep.
Because if someone's getting $585, but someone else is getting $2.3 million, there's a disproportionate
Yeah, could you
something
imagine?
going on
We
with the
put those
2.3
millions into court-appointed counsel or into the education system and maybe
They're
prevent
gonna
this
tell you
stuff
to
to
sign
begin
the
with?
deal.
What's that?
They're gonna tell you to sign the deal. So you're going to go to jail because they're gonna say, hey, I'm only getting $585,
Oh, yeah,
sign this
absolutely.
deal.
Yeah.
They don't care that you're innocent. They
Yeah.
just want you to sign the deal.
There are men on death row that pled out for a death sentence. Like, that is the absence of counsel. If you have an attorney who counsels you into pleading guilty in exchange for a death sentence, I don't know how that is upheld in an appellate court as, a constitutional version of assistance of counsel, but it is. There are other stories too. If we wanted to talk about assistance of counsel, attorneys that have fallen asleep during trial, that have showed up to trial drunk, that have hallucinated during their opening statements and talked to the hallucinations in open court, all of those convictions upheld as effective assistance of counsel. So the bar is pretty low, and counseling your client to accept a death sentence in exchange for a guilty plea is one of those.
In a better and less imperfect system, there would be people in the system who would have those kind of concerns. But given the dynamic system we have now, once a conviction takes place, the only people who really care are the person who's been convicted and whatever legal representation they have. Prosecutors have egos. They're not interested. I think they're usually not going to be interested in trying to find subsequently exculpatory evidence. Sometimes when it comes to their attention, they may develop a concern, and sometimes they very actively psychologically oppose it. You know, in terms of psychology, people have a strong predisposition that anything that counters our received beliefs we're invested in, we have a way of discounting, dismissing, not recognizing the force of. I'm sure very few prosecutors would want to think that they had convicted an innocent person sentenced to death, so they have very powerful psychological motivations, unconscious motivations, not to even be able to consider the real possibility. Now, in a perfect system, I think you'd have some kind of watchdog within every the district attorney's office that would be kind of like the gadfly, who would look at the cases, the approach that the prosecutors were taking, and try to poke holes into it. Within there, and give an opposing point of view. I suspect that doesn't take place too often.
It does, not right now, but it did, and yeah, it has.
I have a quick comment and a quick question. I would take exception to the way you posed the dualism between the approach based on reason and everything else, which the implication is that it's somehow non-rational because it's ideological. That just is not the case. To point out that something is ideological is not necessarily in opposition to a rational approach to anything. All right, that's the comment. And then the question is, do you both find your younger students, when you first bring this up in class, are more for or against the death penalty?
Without a
How do you explain that?
I don't know. I was in favor of the death penalty though, when I was younger. I don't know. What is it?
Were you in favor?
I was, yeah. Yeah, I was also in favor of stronger gun laws and drug laws too, but I'm not necessarily proud of my
It goes down
younger
to
brain.
what Mark says. I would speak to it from tradition, being raised by strong, religious, and this is nothing against them, grandparents. Their word to me, I respect them, God rest their souls, with the utmost. Their word to me was enough.
Yeah.
This is the reason why. Okay, grandma and grandpa, that is enough for me.
Yeah.
Without question. And because I saw no fault in their reasoning, it was sufficient for me. I didn't, you saying something or someone else saying something, but I mean, because I respected them in the sense that everything else they had taught me was truth. This is the reason why. These are the scriptures which support why. That is sufficient enough for me. And I was young, and there wasn't anything else to knock what they said. These persons have murdered, they have done this, and this is their reward. And that's sufficient for me. And now as I grew older, I developed my own reasons for supporting it. And then when I started to understand there were innocent people that could possibly be killed, then I thought about, well, that's touching me in a way. And then these other factors, I started, researching for myself, and it's like, okay, well, what are the options? And that doesn't mean I'm not for it, but I take pause when I think about, okay.
Yeah, there's political conservatism, there's religious conservatism, and there's psychological conservatism, and cultural conservatism, the families which you grow up in. Years ago, I was on, there was a guy that was part of Dan Patrick's radio station, Mike Richards, on the afternoons. So he had me on back one time when I published a little book on church and state, and so he was a very nice guy. Well, so I listened to Mike driving home in the afternoon. Well, they were having a discussion on the death penalty. And people were calling in, quoting the Bible, chapter and verse. So I thought, well, I think somebody needs to call in and quote the Bible against the death penalty. So I did two things. He recognized who I was. I said, well, Mike, I do think there are two particular scriptures that have been mentioned that are very appropriate to this. One I'll simply mention, Jesus was executed, capital punishment, and I think we all recognize that that was a gross miscarriage of justice. So again, you can execute an innocent person. There's also a story in John chapter 8 about a woman caught in adultery. And the men of the city bring this woman caught in adultery to Jesus. And they rightly say, the law of Moses says this woman should be executed. Of course, the law of Moses said both of them should be executed. They only bring the woman, but okay, we'll kind of focus. So I said, but in this scenario, I'm reminding Mike of something he knew. Jesus kind of bent down and he said to doodle in the dirt and famously said, well, let he who is without sin cast the first stone. And one by one, all the people go away, and just Jesus and the woman, go your way, sin no more. I made the point that, yeah, you can quote your Bible verses, your Old Testament verses, but here Jesus directly, and I'll call it a contradiction of what the Bible said in the Old Testament. I thought it was a great point. Then he suckered me, and I don't think he intended to. Well, gee, Mark, what do you think he was writing in the ground? I should have said, Mike, I don't know, but let's not be distracted from this great point that I just made. They were distracted. But you can quote, you begin to understand the role of interpretation, any text, but particularly biblical text. But again, our students are, I think, many of them psychologically conservative, they are culturally conservative, they are religiously conservative, and they're politically conservative, and I'm not discounting it. I'm a pretty conservative person myself. But to be able to move beyond that and begin to question your conservatism may be a stage in which many of them have not reached yet. Apparently you've done that. I've done that. You've done that. Not everybody does that.
But Mark, here's the deal. You don't have to know what was being written in the ground because the context is clear. They left from the oldest to the youngest.
Mm-hmm.
So the longer that you lived, the more you realized that you didn't have a right to pick up that stone, right? And the person who didn't cast it. And I think when you look at these things that you're describing, Sarah, without mercy, without forgiveness, without grace, then, by the way, do we really want fairness and justice? Anybody speed today?
Yeah, I know.
You want that speeding ticket? You're going over the speed limit, so where's the line get cut?
And this is also called teenagers maximalism. He is guilty, let him die. That's right, bro. They always maximalize, you know.
Playground justice.
Good, bad, you know, there's no anything in
Except when it's
between.
against you.
There is a kind of black-white, in other words, dualistic thinking, that a lot of people think in dualistic terms, guilty or innocent. Guilty, no other questions, then apply the full force of the law. I think in our particular cultural circumstances too, there's a kind of desire for a lot of people these days to be tough. Politically tough, you know, that's, I think explains a lot of this vitriol we have between, you know, conservatives and liberals and, you know, the Bernie bros and the Trump MAGA people and whatever. It spills over into that desire to be tough against your opponents and to be tough in favor of your cause. I think spills into everything else we do. And I think that's one of the reasons why prosecutors are sometimes tenaciously held to this, because they have to be reelected and they have to appear tough on crime. And how much tougher can you be on crime to be willing to execute people or to have achieved capital sentences?
Well, I don't think either of you are indoctrinating your students to believe one thing, but my question is...
That's why I don't even know what my students actually say. I've never asked them.
Well, maybe this is more for you then, Sarah. After you have discussed this in your class with them and you've gone over some of the arguments, I assume you do that, do they change their mind?
I don't think many of them do. I don't ask them, though. But what I usually do is take like a anonymous poll, like on like Mentimeter, and I'll display their preferences just in numbers. And then I split the class in half to debate it, but I don't let them choose their side. So if they get randomly assigned to argue in favor of the death penalty, they just have to come up with an argument. So I know that the numbers reflect that the majority of students are in favor of the death penalty, but I don't always know which ones they are. Some of them I know which ones they are, because they're pretty obvious. But as far as I know, they've never changed their mind in class. But they're always very surprised. When I talk to them about things like the cost of the death penalty, or the fact that 166 people have been exonerated since the 1990s, declared factually innocent on death row and removed from death row. Those things are hard to hear and not be moved by them. And so I do sense that students feel like they've gotten information, but I don't know that it's been enough to sway them one way or the other. And I'd be surprised if a student became more punitive in my class. Not that I wouldn't know, but I can't imagine that anything I say would encourage somebody who doesn't believe in the death penalty to adopt it.
Well, maybe short term, but I think maybe what you do, Sarah, and what I hope to do, and what any of us as teachers do, is that we plant seeds. We give new perspectives, we give new insights that later on will develop in some changed perspectives. So yeah, short term, they didn't walk out the door that day thinking differently than they came when they came in the door. I don't expect for that to happen in any of my classes. I don't necessarily expect for anything to happen in a semester, though occasionally they'll tell me they've had some major changes, whatever. But in my own experience, I didn't change my views on, drop of a dime or something. But seeds were planted by professors and teachers. New perspectives were given. And those took root. And after a while, over a period of time, they gave root in some very much changed perspectives. So I suspect that you may be having, and I hope that I'm having, and we're all having, a little more effect than sometimes we think we have.
Hopefully it just doesn't, that's a wonderful way to end, don't you think? Hopefully it doesn't become like the character Strelnikov in the film Dr. Zhivago. He begins as a young man, very optimistic, marching in the streets, and a Tsarist soldier slashes him in the cheek, and we see him later in the film as the most bloodthirsty revolutionary. No mercy, except for Zhivago. He lets Zhivago live. But anyway, yeah, they're seeds. It's seeds, isn't it, as you say? But he's the exception.
Or the guy that was the bad guy in Karate Kid, Cobra Kai, and now he's in a new commercial that he's Koala Kai. More mercy.
Thank you.
Thank you very much.